We've arrived at Part 12 of Bright Ideas, a PTI Nebraska workshop on special education law. In this segment, we'll discuss extreme behavioral difficulties which require removal of a child from the regular education classroom and placement into an interim alternative educational setting, or I.D.E.A.s. We've noted elsewhere in this workshop that a child with a disability must follow all of the same rules of conduct which pertain to other children in the school system unless there is an explicit clause in the child's IEP which states otherwise. If any child is an endangerment to himself or to others, something must be done. When such a child violates a school code of conduct, for each infraction, school personnel may, without parental permission, remove the child from his or her regular placement to an appropriate interim alternative educational setting, or I.D.E.A.s, such as an alternative learning center, remove the child to another appropriate setting, or suspend the child from school. When the child has a disability, the removal or suspension may last for up to 10 school days, or the same lengths of disciplinary action applied to children without disabilities. After a child with a disability has been removed from placement for 10 days during the same school year, during any subsequent removal, the school must continue to provide special education services in an alternate setting. When the school wants to change the child's placement for more than 10 days, a manifestation determination must first be made to decide whether the child's transgressive behavior was a direct result of or manifested by his or her disability, or whether the disability plays no role and the behavior was willful. In the event that the child's behavior is determined not to have been a manifestation of the child's disability, then the school's regular disciplinary policies apply to the child just as they would to a child without disabilities. An appropriate interim alternative educational setting will be found, determined by the IEP team, where the child continues to be entitled to a free appropriate public education, continues to receive services, and continues to progress toward the goals set out in the IEP. The child will also receive, as appropriate, a functional behavioral assessment and behavioral intervention services that are designed to address the behavior violation so that it doesn't reoccur. The question of manifestation is determined by school personnel along with the parents and the IEP team members, who will gather to review all relevant information in the child's student file, including the IEP, any teacher's observations, and parents' observations as well. This team will determine if the conduct in question was caused by the child's disability, or alternatively, if it was the direct result of the school's failure to properly implement the IEP. If either of those cases is determined to be true, then the child's conduct is a manifestation of the disability and not a willful disregard of the code of conduct. When the manifestation determination says, yes, the behavior was caused by the child's disability, the IEP team is required to conduct a functional behavioral assessment and begin positive behavioral interventions and supports, or PBIS, for the child. If such supports are already in place, they will be reviewed and modified as necessary to address the offending behavior, and the child will be returned to the previous placement. Or, if the school and the parents agree, the placement may be changed as part of the modification of the Positive Behavioral Interventions and Supports, PBIS. Under certain circumstances, a child may be moved to an interim alternative educational setting under a special disciplinary action by the school for more than 10 school days, but not more than 45 school days, regardless whether the behavior was a manifestation of the child's disability or not. There are 3 special circumstances. 1. When the child carries a weapon to school or on school premises or at a school function. 2. When the child knowingly possesses or uses illegal drugs, or sells or solicits the sale of a controlled substance at school, on school premises, or at a school function. Or 3, when the child has inflicted serious bodily injury to another person while at school, on school premises, or at a school function. The meaning of controlled substances is pretty clear, as is the meaning of illegal drugs. The law provides us with important definitions, though, of weapon and serious bodily injury. A weapon is a device that is used for or is readily capable of causing death or serious bodily injury, but pocket knives with a blade length of less than 2.5 inches are exempt. Serious bodily injury means an injury which involves risk of death, extreme pain, obvious disfigurement, or the loss or impairment of the function of a bodily member, organ, or mental faculty. The school is required to notify parents of their decision to take disciplinary action immediately upon making the determination, and the school must provide parents with notice of all rights to procedural safeguards available to them in the event they disagree with the child's removal from the regular placement. Parents of a child who has been removed from the regular setting and temporarily placed in an interim alternative educational setting may disagree with the decision regarding their child's placement, or disagree with the manifestation determination arrived at by the IEP team members and the school personnel. In this event, they may appeal the school's decision by requesting an I.A.E.A.s hearing. A school may initiate an I.A.E.A.s hearing to maintain a child in an alternate placement if there is a concern that maintaining a child in the regular placement is likely to result in injury to the child or others. A hearing officer will examine the claims of each side and make a determination to either return the child to the regular placement or order a change in placement to an appropriate interim alternative educational setting for up to 45 school days, based on the likelihood of injury. During such an appeal, the child will remain in the alternative setting until either the hearing is decided or the 45 school day time period expires, unless both parties agree otherwise. Meanwhile, the school system must arrange for an expedited hearing to take place within 20 school days after a hearing is requested, and the determination must be made within 10 school days after the hearing. In certain circumstances, a child who is engaged in transgressive behavior may be eligible for I.D.E.A. protection, even if he or she has not yet been determined to be eligible for special education services. If a referral had been made, that is, a parent or teacher had requested an evaluation, or expressed in writing that the child needed special education services, or expressed concerns about a pattern of the child's behavior to special education or supervisory personnel, the assumption would be made that the school had knowledge of the child's disability, and the protection provisions of I.D.E.A. would be in place for the child and the family. However, a school does not have knowledge of a child's disability if the parent has refused permission for an evaluation or for the start of services, or if the child was evaluated and was determined not to fit the definition of a child with a disability. If the school system did not have knowledge that the child had a disability prior to taking disciplinary action, the child is subject to the normal disciplinary measures applied to children without disabilities who engage in comparable behaviors. A parent may request an evaluation of the child during the time in which the child is undergoing disciplinary measures, in which case the evaluation will be expedited. Pending the evaluation's results, the child will remain in the placement determined by the school authorities. If the child is found to be a child with a disability as a result of the evaluation, the school will begin to provide special education and related services, and the child's placement will be determined by the assembled IEP team. Importantly, the protections afforded by I.D.E.A. to a child with a disability do not prohibit a school district from reporting a crime committed by the child to the appropriate law enforcement authorities, nor do they prevent state law enforcement and judicial authorities from applying criminal penalties to the child for crimes committed. The school is required, however, to ensure that copies of the special education and disciplinary records of the child are transmitted for consideration by the appropriate authorities to whom the school reports the crime. Rarely, students with disabilities who are receiving special education services are convicted as adults under state law and incarcerated in adult prisons. In these cases, certain requirements of special education law do not apply. Such students are not required to participate in general scholastic assessments, and the requirements related to transition planning and transition services do not apply if, due to the student's age, his or her eligibility for special education services ends prior to release. This concludes Part 12 of Bright Ideas, an Introduction to Special Education. In the final part, Part 13, we'll summarize and review the most important parts of special education law.